All right, my name is Kevin Norris. I have the pleasure of introducing today's Rupe debate. We are deeply grateful to the Federalist Society and the Arthur N. Rupe Foundation for making this discussion a reality. We greatly appreciate their commitment to preserving civil and thoughtful public discourse on key legal issues. Our resolution for the debate is: originalism should embrace the general law. How should originalists search for the original meaning of laws when the text alone does not provide a complete answer? Some scholars argue that originalism must look beyond written provisions to the unwritten principles that inform the Constitution's drafting. Some scholars suggest that originalism should incorporate general law, the body of unwritten legal principles that supplied many of the rights codified in the Constitution. Proponents see this approach as essential to recovering the Constitution's original meaning, while skeptics warn of its methodological and doctrinal challenges. This debate will examine whether originalism should embrace general law, what that would mean in practice, and how it might reshape constitutional interpretation. Moderating our debate today is Professor Julia Mahoney. She is the John S. Battle Professor and the Joseph C. Carter Jr. Research Professor at the University of Virginia School of Law, where she teaches constitutional law and property. She is an elected member of the American Law Institute, a founding member of the Academic Freedom Alliance, and serves on the Board of Advisors of the New Civil Liberties Alliance. Her recent scholarship includes works on federal courts and takings litigation, eminent domain, and student loan debt restructuring.
For agreeing to participate in this debate. So I will introduce them, and then I'll just ask a couple of questions to kick us off. Judd Campbell joined the faculty of Stanford Law School in 2023. He previously served as a professor at the University of Richmond Law School, just down the road from us, before leaving for California. And he has been a visiting professor at the University of Chicago Law School, as well as at Harvard Law School. The focus of his extensive scholarship is constitutional history. He has also written extensively in First Amendment law. His publications include articles in the Stanford Law Review, the Yale Law Journal, the Harvard Law Review, Constitutional Commentary, and the Law and History Review. Larry Solem, as needs, I think, no introduction. He is a professor here at the University of Virginia. He is an internationally recognized legal theorist who works in constitutional theory, procedure, and the philosophy of law. His series of articles on constitutional originalism have, I think it is fair to say, shaped contemporary thinking about many of the most important current debates in constitutional theory. Professor Solem received his J.D. magna cum laude from Harvard Law School and his B.A. with highest departmental honors in philosophy from the University of California at Los Angeles. So thank you both for being here. We are absolutely thrilled and look forward to a stimulating discussion. So before we get to the normative aspect, should originalists embrace the general law, I have a couple of basic foundational questions for you both. The first is how precisely each of you defines the general law. And the second is, to what extent, if any, do you think originalist practices already incorporate the general law, at least to some extent?
Thanks. So I'll kick us off. Really delighted to be here, especially at UVA. I'll just say by way of introduction, I arrived at thinking about questions of general law after I had already started doing a lot of work on founding era conceptions of rights. And it came, my first introduction to the idea of general fundamental law. I, of course, was aware of general law as a concept from studying cases like Swift versus Tyson, but my first introduction to the idea of general fundamental law as a concept actually came at a conference that Randy hosted at Georgetown that featured Chuck McCurdy, who was introducing ideas that Michael Collins had laid out and some really important work about the Supreme Court's general constitutional law jurisprudence in the aftermath of the Slaughterhouse case that arose in diversity cases. And so having done a lot of work at the founding, I was like, wow, this concept actually makes a lot of sense of things that I already know to be true about the founders and their way of thinking about the Constitution and of fundamental rights. And so really, UVA was especially important to the development of my ways of thinking about this topic, so I'm especially glad to be here. For me, general law is cross-jurisdictional law, and that cross-jurisdictional law could be of the sort that deals with coordination problems, of the sort that Brad Clark was mentioning in the previous panel, but it could also be based on the notion that there is a shared body of fundamental principles and rules that different jurisdictions all embrace, and that none of those jurisdictions treat as uniquely local law. So the basic idea is that there are certain legal rules and principles that apply within different jurisdictions that none of those jurisdictions treat as being exclusively theirs. They don't have the ultimate authority to propound and interpret those principles, even though they embrace those principles as a matter of their positive law. And these sorts of general law rules include things that are ordinary in character, ordinary law in character, and a lot of the rules in the era of Swift versus Tyson could be displaced by ordinary legislation. But importantly, and here's where the work of Michael Collins really illuminated my way of thinking about founding-era conceptions of rights, the founders and the framers of the 14th Amendment thought that there also existed a body of general fundamental rights. And those general fundamental rights included aspects of the common law that were thought to be fundamental in character. So these are things that legislatures didn't have authority to displace at will. Things like the rule against prior restraints, the right to confront witnesses, the right to a jury trial, right against general warrants, and so on. And then also included certain principles that they referred to as natural rights, as rights of liberty and property that imposed certain limitations on legislative authority. In particular, legislatures could regulate those rights in order to promote the common good, but could not regulate them for reasons that did not promote the common good. So that's a fairly thin notion. It's not a legally determinate conception of rights, but it is a conception of rights that imposes some boundaries on legislative power. And so I think when trying to distill how it is that the founders and the framers of the 14th Amendment are thinking about the importance of general law, it's not that they think they're referring and in some sense making reference through the Constitution to all general law, including the law of nations, choice of law principles, and so on. It's rather this more discrete body of general fundamental law rules grounded in common law and general fundamental law natural rights that they're making reference to. And those, both of those impose limits on legislative power, both at the state and federal levels, although they do so in very different ways and with very different implications, not only for legislative authority, but also for judicial review.
Yeah, well, thank you so much for the invitation. Thank you, Judd, for coming. Judd is an amazing scholar. I always learn from him, and I have certainly learned much about the topic of the general law from his work. So let me suggest that when we deal with the concept of the general law, we need to engage in a particular intellectual exercise. What we are trying to do, we might call conceptual translation. So what do I mean by that? I mean that the conceptual structure of thinking about law in the founding era is not the same as the conceptual structure we have today. So when you encounter a particular founding era concept, in this case, general law, you have to think hard about what they were doing with that concept, and that's probably going to involve learning a lot about their set of ideas and relationships between ideas expressed in a vocabulary that's different than the modern vocabulary. But then translation requires that we do something else. Conceptual translation requires that we understand modern thinking about law and therefore how we could translate 18th and 19th century ideas into a modern vocabulary. This is a supremely difficult task. It's a two-way street. You have to understand the thought world of the 18th and 19th century, and you have to understand our thought world, the thought world of the 21st century, and so that's tricky. And I don't pretend to really have a great grasp of how we should treat the general law at either end of the two-way street, right? I've got a lot of tentative thoughts, but I don't have a lot of firm conclusions. So tentative thought number one involves a simplification that's similar to things that people have already said today. The simplification is this. There is a concept, general law, and I think once we push hard on it in this effort to translate it into modern ideas, the concept general law is what's sometimes called an umbrella concept, right? That is, we have this sort of notion of general law, but then within that notion, there are a number of distinct concepts that are not identical to each other if we are translating the vocabulary of the 18th and 19th century into a more, for us, more precise theoretical vocabulary that gets at what they were talking about. So idea number one, we could associate with the idea of general common law as it existed in the 18th and 19th century. So this is the concept that was affirmed by the United States Supreme Court in Swift v. Tyson. Swift v. Tyson was not doing, in my opinion, not doing anything new or novel. It was recognizing a kind of law that was well established and generally acknowledged at the time Swift v. Tyson was decided. What was that concept? Well, obviously, sort of a basic component of this concept of general common law was that the legal content of the general common law was not tied to the positive law in the sense of the positive law enunciated by particular court decisions of any particular general common law jurisdiction. So the general common law in Maine is the same as the general common law in New York, and this might have been an idealization, but also the same as the general common law in England. So how did that work? For a moment, I just want to give a positive spin on how that could work. This idea of the general common law can be explained via the notion of voluntary cooperation between general common law jurisdictions. So we have some question of contract law, and we think that this is a question of general common law. There's nothing that is peculiarly local about this question. In Swift v. Tyson, the question turns out to be something like, does extinguishment of a pre-existing debt constitute valid consideration, right? And under a general common law regime, what every state, and perhaps other common law nations as well are doing is trying to reach agreement on the general common law. And of course, they are doing this not arbitrarily. This is not a matter that just involves trying to stipulate or enact a general common law rule. We're doing this guided by right reason, might be one way of putting it, right? Or more sort of moral reasoning. Or another way of thinking about it is that this process is guided in part by sort of an immanent structure in contract law itself. That's two different ways of describing what I think of are basically the same thing. If the general common law regime is successful, then what happens is that general common law jurisdictions converge on a common set of rules. Now, that convergence is not going to be perfect, of course not. Disagreements are going to arise from time to time about what the content of the general common law is, but those disagreements will in turn be resolved taking due account of what general common law jurisdictions have generally done about this problem. And so if there's a clear majority rule and we have a system of cooperative general common law, then jurisdictions that express disagreement early on in the process ought to get in line, right? Not because they have to, but because they want to, because they are voluntarily cooperating in this system. And then, you know, you could see Swift v. Tyson as just an example of this in action. As a matter of general common law, is the extinguishment of a debt valid consideration? And the answer to that question was clearly yes. What about those New York court decisions that seemed to be to the contrary? Well, they were old and peculiar. And in 1842, it's highly unlikely that a New York court would have followed those decisions because the New York court would have thought of this as a question of general common law, and the general common law on that question is clear. If it weren't clear that extinguishment of a debt is valid consideration, right, that we'd have big problems in the world of transactions. So that's one concept of general common law, right? General common law as a system of voluntary cooperation. And that's one conception of general common law that's under the umbrella of this more general concept, general common law in general, right? So what about this other part of general common law, of general law, I shouldn't say common, I gotta police my vocabulary here. What about this other part of the general law? This is the part that seems to be about natural rights or fundamental rights. Such rights are perhaps recognized by and reflected in the common law, right? But these fundamental rights are seen at the time as sort of natural rights, rights that all humans have as a matter of right and justice. You know, there's an articulated theory about how natural rights work, and there are many versions of that theory. The version, of course, that lawyers, law students are most familiar with would be Locke's version of the theory, which involved a state of nature. Natural rights are the things that you have a right to do in the state of nature. Those rights are not unlimited because there are laws of nature in the state of nature. For example, in the state of nature, you don't have the right to invade the rights or inflict deliberate harm on others or deliberate harms of certain sorts, right? So those rights, those natural rights, they're very broad and extensive. You know, I've learned a lot from Judd's work on this point in particular, but we've always kind of known that these were very broad rights because one of the examples of such rights that was frequently given is the right to wear a hat, right? So this is something you could do in a state of nature. But natural rights were not conceived of as absolutes, and they weren't conceived of as little mini codes that told you what things you had a right to do in what circumstances. So natural rights were subject to reasonable regulation in the public interest or for the common good. So we might say they're broad rights but thin rights. So we have this, I'm going to just call it the natural rights idea of general law, and it's not identical to, but it is related to the idea of general common law as a system of voluntary cooperation, right? These two ideas are conceptually distinct ideas. And at this point, you probably will have noticed that these two conceptually distinct ideas have their hooks into other ideas, right? So the positivist interpretation that I've just given of the general common law has its hooks into contemporary legal positivism. Not then, it didn't have those hooks in then. Obviously, HLA Hart and modern legal positivism didn't exist as a way of thinking about law then. But if we're going to translate their ideas into our conceptual vocabulary, those hooks become important. And likewise, this other idea of general law, it has its hooks into natural rights thinking and probably natural law thinking as well. And then modern thinking about natural rights and natural law is quite different than founding era thinking. So there's a lot of conceptual translation that has to take place for us to adequately understand the ideas that they had, right? So that's a very long answer to a very short question.
All right, well,
There are multiple ideas of what general law is.
another shortish question, even given the multiplicity of ideas about general law, to what extent do you think originalism is here already? To what extent has originalism already embraced general law? One obvious possibility is in property, which Judd and I both teach. We certainly see in recent Supreme Court opinions, in effect, references to some kind of what one could certainly call general law, some idea that sources of property rights, although for the most part are express state law, state statutes, state court decisions, there is something that almost anyone would call general law, arguably. And there are others too, right? Fourth Amendment, First Amendment, and so forth.
Yeah, so I think this is a tricky question because it's yes and no. That is that when you set up a way of thinking about law and you create a document that presupposes that way of thinking, and you create particular doctrines that presuppose that way of thinking, and then you run that system for 150 years, and then eventually ways of thinking about jurisprudence change, and you abandon the concept itself, the underlying doctrines will still have been informed by the previous ways of thinking, and the basic framework for the system will still only really make sense in light of the previous ways of thinking. And this just creates real tensions in constitutional law that have to be sorted out. And so the idea that the Constitution itself is the source of your liberty, and that the Constitution itself supplies all these rights of liberty, is kind of strange. And it's something that the court has to wrestle with in substantive due process cases. And it does so in like very ham-fisted ways, But ultimately, it arrives at a notion that there are limits on the ability of states to constrain liberty. And then they have to figure out what to do with that, and they come up with a Glucksberg test that looks to a longstanding traditional practice at state court levels, state legislatures, and so on. And I think what they're doing is sort of approximating an older idea of general law, not because it actually is general law. They've lost the concept of general law, but because the framework for thinking about questions of substantive what we now would call substantive due process rather than just natural liberty cases or police power cases just doesn't make sense without something filling the gap. And the something filling the gap here is like sort of gesturing at earlier ideas of general law because we have become acclimated through history to those ways of thinking. So it's sort of embedded in the doctrine. It shapes practices going forward, even though our kind of intellectual framework for understanding the phenomenon is profoundly changed. And I think the court is dealing with something like that in the takings cases. You could go full-fledged realist and just say property law comes from state laws get to define property however they want, but then you have a real problem making sense of the takings clause, because if state law can define property however it wants, you're going to end up without any substantive protection for property rights. And so the court, without self-consciously overturning Erie or trying to return to an earlier understanding, is having to grapple with that. If we want to give meaning to the takings clause, we have to do something that recognizes the sort of common character of property. And so I think that it's not a return to the general law as a theoretically justified endeavor, but it is a reflection of an older tradition and a recognition of the need to deal with problems, constitutional problems that arise, that really just don't make sense without understanding the legal landscape in which those original constitutional provisions were embedded.
Professor Solom.
I agree, I think, with everything Judd said, but with perhaps a slightly more optimistic twist. Optimistic for originalism, that is, but also a recognition of how difficult and complex it's going to be. So let me just give 3 examples of how general law, in one sense or another, might operate in constitutional originalism. And let me start with what I think is a simple example that illustrates the role that the general law has to play for an originalist. So the 7th Amendment Preservation Clause provides that the right to jury trial at common law in cases where the amount in controversy exceeds $20 shall be preserved. This is the Preservation Clause. And what does it preserve? It preserves the right to jury trial at common law. And what does that mean? It does not mean the right to jury trial under New York law as opposed to New Hampshire law, as opposed to Georgia law. There were variations at the time, but from the very beginning and to this day, to the extent the Supreme Court takes the 7th Amendment seriously, which it doesn't always, it relies on the idea that there was a general law, a general common law that established the right to jury trial. Now, the court sometimes goes all positivist on us and says, well, no, it's the positive common law of England. But I think that would just be a misunderstanding. England was especially important, of course, because they had extensive reported decisions and a very developed legal system. So if you really want to know what the general common law right to jury trial is, you probably want to go to English case law for evidence of that, because it's the best evidence. So this is general common law, right, that originalists, I think, must embrace if they're going to be true to the constitutional text. Second example is the example Judd focuses on of unenumerated rights, right? So here, I think once again, originalists are going to have to take ideas about the general law seriously. And now, I would just want to say, I am hardly an expert in the relevant historical material. So I'm going to advance a tentative hypothesis, but I'm not going to claim that I have the evidence to show that that tentative hypothesis is right. And it's clearly an oversimplification. You know, you'll just have to forgive me for oversimplifying for reasons of time and clarity. So, the Ninth Amendment. The Ninth Amendment is explicit. The enumeration of certain rights in this Constitution shall not be construed so as to deny or disparage others retained by the people. So much hangs now on what are others retained by the people. There's a big debate among historians on that. Professor Barnett is famous for his participation in that debate. Judd's former colleague at Richmond, Kurt Lash, has a different interpretation of what others retained by the people meant. But, you know, there is very strong evidence, and I'm not saying whether this position wins the day at the end, but there's very strong evidence that the other rights retained by the people were understood as natural rights, and those natural rights, which are not enumerated, cannot be denied or disparaged by virtue of the fact that they were not enumerated. We're going to have to figure out exactly what that means, but you can see how this would suggest that unenumerated constitutional rights have the same status as enumerated constitutional rights. Now, that'd be very problematic if rights like the right to wear a hat were considered absolute. But if we adopt the view that natural rights are very broad, but that they're thin, we have a more tractable understanding of what that would mean for constitutional practice. What about the 14th Amendment? Judd mentioned substantive due process, and that makes my skin crawl. Right? Now, my dear friend Randy thinks that there is a substantive component to due process, and who knows, he may be right. But if there is a natural home in the 14th Amendment, Section 1, for natural type rights, general law rights, right, it would have to be the Privileges or Immunities Clause. But I think that between 1791 and 1865, thinking has changed a little bit, so that the fundamental rights or basic rights protected by the Privileges or Immunities Clause are perhaps derived in a different way. There might have been natural law interpretations of that clause, but there's another interpretation that makes the existence of a privilege or immunity dependent on some kind of consensus, not universal consensus, but some kind of consensus, right, thinking about what the rights were. There are some things that are clearly in: the right to own property, the right to pursue a lawful occupation. There also was agreement that the rights in the first 8 amendments to the Constitution, or at least most of them, get in as privileges or immunities. So this is a concept of general law that focuses on general rights, not necessarily operating in the same way as the general common law did with respect to property and contract and other areas. What about the property case? You know, very interesting case, right? So I'm inclined to think that Judd is right, that if we're going to make sense of the constitutional text, we have to have some understanding of property that is not sort of a 21st century positivist conception. Positivist isn't exactly the right word, because what I'm going to be describing a sophisticated positivist could endorse, but positivist conception of property where property just is whatever the state says it is. No, that's not going to work, because the Constitution won't make sense that way, right? It won't make sense both in the Takings Clause and also with respect to the Due Process Clause under modern interpretations anyway. It would seem like if property is just whatever the state says it is, then Justice Rehnquist, or Chief Justice Rehnquist's idea that you must take the bitter with the sweet, right, it would imply that the state could just define property in such a way that it wasn't taking anything under the Due Process Clause. That can't be right either. So these are ways in which originalism should endorse the general law, or one of the senses of the general law. But look, I think there's other parts of the general law that originalism should say are extra constitutional, or they aren't constitutional in the sense that, say, public meaning originalism conceives of what is constitutional. For example, like there's a rich general law that and there are certainly remnants of it today, of trusts and wills, of the law of agency, not to mention the law of contracts, the law of torts, law of property. Now, some aspects of that general law may be important to understanding particular constitutional provisions, but other parts, like, you know, the general law of the tort of battery, right? It might be that although that might play some role in identifying particular rights violations, the Constitution doesn't constitutionalize all of tort law, all of the law of trusts and wills, all of the law of agency, and on, right? That stuff is left to other mechanisms of legal change, including legislation and common law development through common law courts in the states. And it may be that the Constitution just doesn't control most of that, and therefore that part of the general law, originalists should say, that's not mandated or incorporated in by the original public meaning of the constitutional text.
So your remarks from both of you raise the question of to what extent can originalism embrace the general law? In particular, you, Judd, suggest that perhaps some aspects of the legal culture that produce the general law are dead, are gone, unrecoverable, unknowable. Is this right?
So I think there are a couple ways of approaching this. So one thing is you need to figure out what originalism means in order to figure out whether it's compatible with the general law at a conceptual level. And it could just mean that originalism is all about understanding the meaning of text and treating that text as positively enacted law, and not allowing for the notion that the text could be making reference to a body of unwritten fundamental law. And if that's your definition of originalism, then you don't need to deny the existence of general fundamental rights. It's just irrelevant, because what you're looking to is the subjective assessment of what the rights entailed by the people who enacted those constitutional provisions, which are the very thing that gave those constitutional provisions legal status. This is Justice Scalia's view. We can avoid endless debates over natural law and over the content of the common law by just looking to what the particular people who enacted these constitutional provisions thought. And if that's your understanding of originalism and you have an adequate jurisprudential basis for it, then I think there's an incompatibility between originalism and general law, definitionally. That's not the only way of approaching originalism. So you could have a more capacious understanding of what originalism is all about, that originalism is about trying to understand the law at the founding including not just legally enacted texts and the meaning that came from those legally enacted texts, but other potential sources of fundamental law, and then evaluate that whether those other sources of fundamental law embrace, as a empirical matter in looking to the historical materials, other sources. That way of thinking about originalism is at least allowing for the possibility of in recognition of general fundamental law. But then you raise the question, well, what do you actually do today? And I think there are real challenges. And what you have to grapple with is an effort to bring earlier concepts into a present-day legal culture that makes those earlier concepts difficult to understand and apply. And one way of doing that is just by force, by reintroducing the concepts to our legal culture and trying to get a foothold. This is basically the move of originalists' early efforts to try to reshape legal culture as part of a way of reshaping the law. I don't know that it's likely to succeed, but it might. Legal change happens in unpredictable ways. Another approach would be to try to translate earlier notions of general law into a legal culture, either as an intermediate sort of stepping stone towards a general embrace of general fundamental rights, or as just an alternative for a world in which we've lost the earlier ideas. And I think that's at least possible. You could construe what the court is doing in cases like Rahimi as something like that. You could construe what the court is doing in cases like Dobbs as something like that. This is basically the project of my co-authors, Will Baude and Steve Sachs, to try to recognize commonalities in our existing ways of thinking about fundamental rights questions and to try to tie those to an earlier tradition in a way that at least brings them into conversation, that grounds current approaches in something true about the past, not just about the original meaning of text, but about this sort of broader, more capacious understanding of fundamental law.
So now I'm going to disagree with Judd in a certain way. So I think he's got two alternatives and an excluded middle problem, right? So I certainly agree that we could imagine a form of textualism that would somehow negate the general common laws playing a role in constitutional interpretation. It's going to have to do a lot of heavy lifting to get there. Like, it's going to have some explanation as to how we can interpret the Seventh Amendment without general common law. It's going to have some stance on the Ninth Amendment, which is part of the constitutional text, and the Privileges or Immunities Clause, which is part of the constitutional text, that somehow does away with the general common law. Now, there are versions of that. You know, most famously, Robert Bork said that the Ninth Amendment is an ink blot, right? And I don't think that public meaning originalism and originalism that takes the text seriously must say that part of the text is an ink blot that is to be erased by the Supreme Court. Likewise, Justice Scalia was extraordinarily hostile to the Privileges or Immunities Clause, famously attacking Alan Gura in the oral argument in McDonald versus City of Chicago, and ridiculing him for arguing that the right to bear arms should be understood as a basic right protected by the Privileges or Immunities Clause. So you could be that kind of originalist, but I just think that that's not really originalism. Real originalism of the public meaning originalist sorts can't erase parts of the constitutional text and therefore must embrace the general law. So, you know, Judd poses as the alternative what is sometimes called original law originalism, and that's an alternative too, and that will treat the general law in a different way, and then we have to have a debate. I think it's a theoretical and normative debate about what form of originalism is best. But the version of originalism that I think is best, public meaning originalism that does not erase the constitutional text, has to engage with the original law seriously. But then this creates a problem that Judd identified. It's a really serious problem. How do we get contemporary judges to appreciate the implications of the Ninth Amendment and the Privileges or Immunities Clause? It ain't gonna be easy, right, for a variety of reasons having to do with the psychology of individual judges and justices and the sociology of judging in general, but also the sociology of sort of originalism as a movement in legal thought and also partially a movement in politics, right? Not easy, and it might take a long time to get originalist judges to appreciate the role that the general law must play, right, in the domains where the general law is important. So that, I'm not saying it's an easy task, and I'm not saying we're going to be able to do it by next term of the Supreme Court, or the term after that, or the term after that, right? This is a long-range project. Of course it is, right? It took us decades and perhaps centuries to lose the concept of the general common law, you know, so why would we think we can get it back in 2 years or 5 years or 10 years? I think we're talking decades here, but I have a long-run perspective. Okay, it will take decades, but that doesn't mean we shouldn't start the work now.
Right, so in starting this work and thinking about the revitalization or rebuilding of a legal culture that grapples with general law, the question arises, what is the role of popular culture? Larry Solem mentioned politics, and what is the role, in effect, of the people and institutions other than courts taking a leading role in interpreting the Constitution?
Larry, you want to start?
I don't know. It's a hard question.
It is, but it...
Julia's asked a very hard question.
But it follows from your remarks. I think, doesn't it?
Absolutely, totally fair. It does follow from my remarks. But it's just a really tough question. So yeah, we got a lot of problems here. I dwell in the world of constitutional theory, high constitutional theory, right? And so I'm not necessarily the right person to ask how we can translate theoretical ideas into the general, there's that word again, the general legal culture, and much less the popular culture. These are difficult things. I do want to say that if originalism is perceived as the partisan program of one political party, I don't think that it has a chance of becoming sort of the consensus method for understanding the Constitution. So it's important, therefore, if you care about originalism, that you think about originalism in nonpartisan ways and recognize that some parts of the Constitution, if you're a conservative, may have progressive implications that you don't like, and of course, vice versa. As a first step, but this step's going to take a long time, it's not going to happen immediately. As a first step, it would seem to me that ideas about the general law need to be incorporated in the law school curriculum. So that means not not teaching Erie Railroad versus Tompkins, sort of in the, along the lines suggested by people who are true believers in Brandeis and in Justice Holmes's aphorism that, what he was really talking about was the general law, that the general law would have to be a brooding omnipresence in the sky. That is, exposing first-year law students, not only in constitutional law, but throughout the curriculum, to ideas about general law. And of course, nearer and even dearer to my heart, about originalism and textualism, sort of across the board. This audience is testimony that that can happen, at least at some law schools. But of course, it does not happen at many law schools. And I am quite sure that there are at least 100, and I think that's a gross misunderestimation, law schools where originalism is never discussed with anything other than conclusory derision, and where the idea of the general law is never mentioned at all.
Thank you. Professor Campbell.
Yeah, so there's a lot to say here. I'll just focus on one aspect of this that I think is particularly important, but also particularly challenging, which is that if you're trying to defend an older conception of the way that the regulation of fundamental rights occurred, it's through impartial legislation. It's through legislation passed in order to promote the common good. And I think one of the difficulties in our present moment, and this has been true for a long time, is that we've lost a sense not only that there is a common good, but also that it is even conceivable that a legislature could aim to promote it. Our conception of what politics is as just rent-seeking, as partisanship, as efforts to claim power, as efforts to advance the interests of the special interests that have promoted the politicians into office is just very deep-seated. We have an extreme level of cynicism about politics, and I think that's true at the state and national levels. And so in order to resurrect an earlier conception of the regulability of rights, you have to return to a culture in which people are comfortable with legislative regulation of rights. And that's just not something that's going to be easy to sell right now because our politics is so bad, not just in real terms, but also in terms of how much faith we have in the ability of this to work. I think that the separation of law and politics that the Federalist Society has advanced has been rather healthy on the law side. That is, trying to make interpretations of law something that is more rigorous and more scientific and less prone to value judgments of subjective decision makers, subjective value judgments of particular decision makers. I think it has gone a little bit too far in a variety of ways, and that we've sort of taken the normativity out of law in certain ways that are deeply contestable. But I think on the whole, the idea of disciplining law to do better is a virtuous thing. The flip side is very, very bad, though, which is that just because you're in the realm of politics, anything goes. And if that's what you think, you're not thinking along the lines that the founders thought. They did not think that anything goes in the realm of politics. They thought that politics had to be aimed toward the interests of the society as a whole and its members. And one of the things that is going to be necessary were we to try to return. Now, obviously, that's an aspiration, right? It's never achievable in perfection, but the idea that something is never achievable in perfection does not make it not worth pursuing. And so one of the deepest challenges of trying to return to an earlier conception of rights is trying to unring that bell. I think it's going to be a very difficult bell to unring, but I think it's very much worth trying.
Thank you. We have some time for questions from the audience. Yeah, excellent. Stephanie, Professor Barclay.
Can you hear me? Okay. We're hiding off in the comfy chair section. Sorry about that. Judd, this is a question for you. When you described those two options of your take of public meaning originalism that's very textualist and ignores the general law versus original law originalism, I had sort of a similar reaction that Larry did. Like, I think there's a different type of public meaning originalism which can recognize and incorporate general law when appropriate. And so I'm just curious, if you are contrasting original law originalism with that version of public meaning originalism, what daylight do you still see? What are points of disagreement, areas where there needs to be reconciliation?
Yeah, so I think that is worth considering, that we look to the original meaning of the text, but the original meaning of the text sometimes points us towards bodies of general fundamental law. I don't take that to be the countervailing position in our dominant legal culture, even though it might be Larry's position. So I was just trying to set up a sort of counterexample in which the idea of general fundamental law wouldn't fit. But I do think that's possible. And it would bring ideas of original public meaning originalism into greater alignment with ideas of general law, original law originalism. There are possible differences, though. So you could imagine an original public meaning originalist construal of, let's say, the Ninth Amendment in a way that does not make space for unenumerated fundamental rights having the same status as enumerated fundamental rights. And that depends on what the original public meaning originalist ends up determining about the meaning of the Ninth Amendment. The thing that I want to emphasize here is the status of unenumerated rights for the founders did not come from, was not determined by the meaning of the Ninth Amendment. Right? So the Ninth Amendment might say one thing, and their thinking about fundamental rights might be another. And I just want to lay that conceptual possibility on the table. I'm not going to defend it. I actually think the Ninth Amendment probably does reveal a way of thinking about rights, although it doesn't say unenumerated fundamental rights exist and have the same status. It very much implies that. But the point here is that for somebody who has a general fundamental rights view, like I think the founders did, they would not have answered the question of the status of unenumerated fundamental rights by looking to the Ninth Amendment. Rather, the Ninth Amendment is just a reflection of the way that they thought about that question. And so you could potentially see space. Whether you're actually going to see space in practical disputes is going to turn on how original public meaning originalists construe these various constitutional provisions.
Thank you. Other questions? We had one, I think, over there.
Thank you for coming, professors. I'm just wondering, so originalists will be obliged to read the Constitution in this framework of the general law. Will originalists be obliged to think that they were right in thinking about the general law that way, and so adopt a general law theory now for practice?
Obviously, the answer to that question depends on many things, right? What version of originalism we're talking about, and then say we were talking about public meaning originalism, it's going to depend on the meaning of particular text. Does originalisms as a theory require that I'm going to just exaggerate your question a tiny little bit. Does it require that we return to the thought world of the 18th and 19th century, and that we organize our conceptual world the way they organized their conceptual world, right? So if that's the question, then the answer is no, right? That things that happened at the founding and at the time each constitutional amendment was framed and ratified have important normative significance for us. If you're a public meaning originalist, that's because you believe that there are strong normative arguments that we should treat the constitutional text as having binding force today. And Judd is right, that that approach to things is not the same way that these questions would have been thought about in the 18th century, right? They lived in their conceptual world, not ours. And they had their normative concerns, not ours. And they had their beliefs about how general law would work. And those were beliefs about the conditions they faced, not the conditions that we face. So putting it another way, we can't escape the fact that we live today and that we inhabit a conceptual world where the concepts of the framers require translation, right? We're not going to emigrate from the 21st century and start living in the 18th century. We have to translate their ideas into modern ideas. We have to think about the normative significance of the text that they adopted from our perspective. And let me just be clear, I'm not saying we get to disregard it. I'm just saying that our reasons for taking it seriously and considering ourselves bound by it have to be our reasons today, not their reasons then. So I think that we can't, we do need to try to understand concepts about the general law and translate them in a way that they make sense to us today. But that doesn't mean that we have to become 18th century thinkers and think about law the exact same way they thought about it in the 18th century. I don't think we can do that. Even if individual scholars can do it by immersing themselves in the 18th century, as a legal and political culture, we just can't do that. Translation is the best we can hope for.
All right, thank you very much. We have run out of time. So thanks to our panelists and thanks.